Let's take a look at deeds, something you encounter every day in the real estate industry. Before we delve into deeds and what they are, we have to first understand the nature of ownership of real estate. Legal scholars define ownership in real property as a bundle of rights like a bundle of sticks. One can do many things with real estate. You can own it outright, you can rent it, sell part of it, sell rights to the parts underground or on top, sell rights to the fruits that come from the land, lease it, pledge it as collateral for a loan, sell it to someone for the duration of their life, even set conditions for future ownership. With all of these rights to land, it's no wonder that there are a significant number of deeds that can be involved in a transaction. The first rule of real estate conveyance, having the rights to real estate change hands, is that you can only convey that which you own. In other words, you can't sell something you don't already own. If a piece of property is pledged as collateral for a loan, then the owner has given up a few sticks in her bundle of rights. The person buying the property takes it subject to the rights of the lender. The new owner only has the sticks the prior owner had left over. The only way to recover those missing sticks and make it a complete bundle is to pay off the lender and have him convey his rights back to the owner. It all sounds very theoretical and esoteric, but these are the transactions we deal with every day in the real estate industry. The type of deed used in a transaction is based on the bundle of rights that the seller has, and what part of the bundle she wishes to sell. A deed is a document that conveys or transfers an interest in real property. As we said before, the interest could be total ownership or a limited form of ownership. The concept of the deed dates back to the Bronze Age and perhaps earlier. The Jewish Talmud tractate Bava Basra discusses how ownership of land can be shown by a shtar, a document reflecting a change of ownership from one person to another. For safekeeping, these documents were placed in clay jars and stored underground. The concept carried down to the present day, though today we store deeds in a county record room in books and file cabinets. From here, we see that deeds have two purposes: to transfer ownership of land from one person to another, and to prove ownership of a parcel of real estate. Usually, there are two parties to a deed: the grantor and grantee. Later, we'll talk about judicial deeds, where an officer of the court is a third party. The grantor is the person selling the land, and the grantee is the person buying the property. So, when you're confirming ownership of a property, you would want to look at the grantee of the deed. It is important to note here that the person doesn't have to be a human being. A person in the legal sense can be any legal entity, like a corporation, a limited liability company, a trust, or a partnership. All of these entities can own and convey property similar to a human being. The deed itself contains the names of the grantor and grantee, the date of the transaction, a legal description of the real estate, described by its boundaries relative to other real estate, and the signature of the grantor. The grantor's signature is notarized, meaning an independent person confirmed the identity of the signer to be the owner of the property listed in the deed. A significant part of the deed is the warranties. Warranties are promises about the property made by the grantor. Essentially, the grantor is saying, I own this property. My rights to the property are limited by certain conditions, and I promise you, the grantee, are getting the property as it is described in the deed. The warranties are what distinguishes one deed from another. Here are some of the deeds you will see in your travels in the real estate industry. A general warranty deed, or warranty deed in some states, is the most common type of deed in real estate transactions. It provides the most protection for the buyer, the grantee. In a general warranty deed, the grantor promises that no one has other claims of ownership of the property, no encumbrances, like mortgages or liens, no boundary disputes, and also promises that based on the prior owner's period of ownership, these warranties are valid forever. In order to give a warranty deed, all liens have to be paid off at closing, and a title search must be conducted to make sure there are no other outstanding liens or issues. With a special warranty deed, the grantor only covenants that the property is not encumbered by mortgages or other liens, and that the grantor has title to the property. This type of deed is commonly used in commercial real estate transactions where the grantor is a company that wants to limit its liability in the event a problem with the title pops up years down the road. Also, commercial real estate may be more complex than a simple home lot, which has been a home lot for over a century. Commercial real estate can be carved and reshaped over years of transactions between companies. A grant deed is similar to the special warranty deed. The grant deed assures the grantee that the property has not been sold to anyone else. Therefore, the word grant. Also, warranties are limited to the grantor assuring that he has ownership of the property, and that the property has no liens or encumbrances. A bargain and sale deed is an even more limited list of warranties. Here, the grantor simply warrants that they have done nothing to harm or cloud the title to the property. This vaguely means that there are no liens or encumbrances, but there may be issues from prior owners that were not resolved by the current owner. A bargain and sale deed is commonly used where neither party wants to undergo the expense of a title search, or does not want to take on the expense of clearing up earlier title issues. The hope is they won't cause the owner problems, like losing the property to an unknown lien. The price of the property may be lower if it's conveyed by a bargain and sale deed rather than by a traditional warranty deed. A quitclaim deed offers the least protection for buyers. Here, the grantor is conveying whatever interest they have, which could be none. In this case, the buyer is urged to conduct a thorough title search to make sure that they're getting the property free of liens, easements, and encumbrances. If the seller is not willing to warrant rights of ownership, the buyer should beware. Just like the bargain and sale deed, properties conveyed by quitclaim deed may have a lower market price, but the buyer will assume the risk of whatever surprises are found in the title history of the property. Sometimes property transfers aren't voluntary. Occasionally, courts get involved in real estate disputes. The dispute may involve two owners fighting over a boundary line, or a lender exercising their right to seize the property pledged as collateral for a loan. Certain courts have the power to order the seizure, division, or transfer of real estate. This power is called equity. If the court finds, based on a state law or contract, that the transfer of property is appropriate, then it will issue one of the following types of deed. The type of court-ordered deed will depend on the nature of the dispute. The sheriff is usually the primary law enforcement officer of the court. When the court exercises its power to order the seizure or resale of real property, the sheriff usually conducts the sale. An example is when the court issues a money judgment against a defendant, but the defendant refuses to pay. If the defendant owns real estate free and clear of other liens, the judge can order a sheriff's sale of the property to satisfy or pay off the judgment. The sheriff conducts an auction sale on the courthouse steps and conveys the property to the buyer by sheriff's deed. The warranties of the sheriff's deed are similar to a quitclaim deed. You'll encounter a tax deed when the owners of real property do not pay their property taxes. State law allows a county official to sell the property to pay off the taxes. This is a type of seizure of property. Buyers have to be careful of a tax deed. A tax lien is a kind of superlien that allows the county government or whatever division of government is owed taxes to auction off the property even though it still has other mortgages or liens on the title. The buyer takes the property subject to all existing liens. The buyer may also have to wait a period of time to fully have title. The previous owners may have a right of redemption, which allows the previous owner to pay off the owed back taxes and fees to recover his property. A trustee's deed is a type of deed used after a foreclosure sale. In states where a mortgage on property is accomplished by the owner giving a deed of trust to the lending bank, a foreclosure sale ends with the deed of trust going from the bank to the new owner. Like other deeds based on foreclosure, the warranties are limited. All liens subordinate to the mortgage will be wiped out by the mortgage sale, but tax liens, easements, and certain other limitations on title may follow with the property. Like a trustee's deed, a deed under power is a type of foreclosure deed used when a mortgage is conveyed by a security deed. It also contains limited warranties, and title may be taken by the grantee subject to easements, tax liens, and other limitations. The simple and efficient concept of the deed is complex. Understanding their nature and flavors will help you understand the world of real estate in all its variety and possibilities.